Well, hello, friends, and welcome to Uncivil Law, the channel where we learn from the misfortunes of others. I'm your host, Uncivil Law, and of course, tonight we will be doing some bourbon. Tonight's choice is Pecan Praline, which I believe is actually Canadian, so not technically bourbon, but whatever, it's tasty. We are here with day number 9 of the Kyle Rittenhouse trial, and the case is closed. All the evidence has been submitted to the jury. What is left for the jury now is to receive the jury instructions and the 5 hours, give or take, of closing arguments, which is unbelievably painful. So tomorrow is going to be the day when they're going to go over jury instructions on other things. Now, if the defense has any sanity on the face of this earth, they will have written a motion and they'll submit a motion tomorrow to have this case dismissed with prejudice, dismissed in the lack of insufficient evidence, failure to make the case, directed verdict, and all that stuff. And if the defense has any sanity at all, I'm not saying that the judge will grant it. I don't know if he will or not. If you're a betting man, you'd have to predict against it. You'd predict against it at the end of the state's case. You'd still predict against it at the end of the defense's case. Because once again, if the jury comes to the right conclusion, then you don't have to do anything. So you don't have to intervene. So you typically only see these sort of interventions when there is a true failure to meet a element of the charge. Not like they failed to prove venue or failed to prove it or failed to argue it was the guy. So it's not typically granted at a preliminary stage unless you have something truly outrageous. And there's the prudential reason for it. If the justice has to be done and seen to be done. Justice has to be fair and seen to be fair. So the courts are cognizant of both these concerns. And a legal conclusion which says that these charges are not sustainable would be a fair or just result, but it might not be seen as a fair or just result. Plus, having the community as part of the process and not yanking them out of the process is more in keeping with the understanding of the jury system as a whole. So you would predict against it. That being said, however, you'd have to be absolutely certifiable insane not to ask for it, because you have pretty solid cause, all things considered, at this stage compared to most of the cases. And it is very normal for defense lawyers to just pro forma automatically ask for these things. It is very, very common. Some people just do it routinely in every case, no matter how bad it is, because you never know. Maybe the judge fell down in the bathroom that day and they're confused or something. So the fact that they didn't ask at the close of the prosecution's case was upsetting and weird. If they don't ask tomorrow, it's probably malpractice, to be quite honest. But given the trend we've seen from the defense, will they ask? I don't know. If they do ask, they're going to have an argument about it. They've got cause. First of all, they've got the constitutional violation where the prosecution was actively warned against referring to the defendants not commenting, and then did it again anyway. And the judge has already reached the conclusion that the prosecution didn't have good faith, that he was doing it with bad faith in mind. So it seems that the judge has already reached all the factors he needs to say this is a mistrial with prejudice. The difference being that whether the prosecution did it deliberately. Did they deliberately, intentionally do it for the purpose of invoking a mistrial? Did they try to do it because they knew the case was going so poorly that they wanted another crack at it? And so they're trying to provoke the mistrial. Well, you already have the finding of bad faith. So it seems like you're there. So given that, you would think that the motion to dismiss with prejudice based on prosecutorial misconduct, you have a pretty high chance of it being granted, because it seems like the judge has already reached the predicate conclusions necessary to reach the finding. So why not ask for it and put him on the record either way? And also on the charge, on the case of asking for a directed verdict or dismissal based on the failure to prove the case. The prosecution has the affirmative burden to prove the lack of self-defense. The starting proposition is Kyle does have self-defense. That's the baseline. Kyle does have self-defense. The prosecution has to prove that he doesn't. And they have to prove he doesn't beyond a reasonable doubt. So they have to prove that they have to prove objectively or subjectively that Kyle lacks it, right? Because the defense has to prove both. Kyle has to prove both objective and subjective. So in order to defeat it, the prosecution only has to prove one, because then Kyle can't prove both, right? So they have to prove either subjective or objective. Because Kyle subjectively not have fear? Well, that seems impossible. They would specifically called out, if I get you alone, I'll kill you. He had people with guns trying to kick him in the head, trying to beat him in the head with a skateboard. And in the overall climate of the chaos of that night, the idea of the subjective intent, and we heard from Kyle himself testify to that. We heard other people testify to his subjective knowledge. So it's just not coming only from Kyle. So it looks like Kyle has subjective knowledge and subjective belief. So I don't think the prosecution can prove the lack of subjective belief to beyond a reasonable doubt. Like, you might not fully believe it, but how do you get to beyond a reasonable doubt is beyond me. So the only thing left for the prosecution is be able to prove the objective. It's objectively unreasonable. An objective person, the reasonably prudent person, the reasonably prudent man, the man on the bus, as we say in law, the man on the bus, would the man on the bus feel this level of fear? And again, in every situation, it seems well proven. The prosecution tries 8 different ways of breaking it down and slowing it down and being like, well, at frame 523, if we look at frame 523 in this slow-mo, it looks like your rifle is pointed at his leg and his gun isn't yet pointed at your head. Why did you point your rifle at his leg before he pointed the gun at your head? Why did you fire the gun? Why did you fire your gun before he fired his gun? Why didn't he shoot you in the head first before you pulled your gun out? And so forth and so on, right? So it seems kind of absurd. It seems absurd. Can you get to he lacked, or more properly, a normal person, a normal, ordinary, prudent person, which incidentally, for the purposes of this exercise, means the jury. That's the reasonably prudent person. The jury. So would the members of the jury think it's objectively reasonable for him in that moment to pull the trigger? And I think the answer is yes. They tried to show that he instigated, they tried to show a whole bunch of things, but I don't think it really goes anywhere, and certainly not beyond a reasonable doubt, which again is the standard that the prosecution has to get to. So for my money, I think that you have pretty high odds for a motion to dismiss for failure to state it / directed verdict / judgment as a matter of law, or whatever Wisconsin is calling it. It all amounts to the same thing. Given these standards, could a reasonable jury conclude beyond a reasonable doubt that he lacks self-defense? And it seems like the answer to that question is no. Now again, you would still have to predict against it. You still have to predict against the judge granting it. Because again, if the jury comes to the right conclusion, then you don't have to intervene. And then it's not the mean, angry judge who did anything. It was the jury doing it, right? And that's the process people tend to accept. So it's justice seeing to be done. But if the jury comes to the wrong conclusion, you can fix it at that point, assuming that you're going to fix it at all. So again, even with all that, even with the legal standards being what they are, for prudential reasons, for policy reasons, you would still predict against the judge granting it. Or he might still keep it in reserve until after the jury comes back, right? He might keep it still under advisement until the jury comes back and deal with it then. and granted as part of a, collective thing. So I'm going to grant a judgment notwithstanding the verdict. In the alternative, I'm granting a dismissal, for prosecutorial conduct. In the alternative, I'm granting a dismissal for failure to make the burden of proof necessary at this stage. So he might do it all at one time, assuming he's going to do it, right? So it's like I'm dismissing it for all these reasons simultaneously, which is definitely something you could see happen. So but still, I think the defense has to be crazy to not make the motion, because it's a thing the Court of Appeals can review if he's convicted. And you still make the judgment notwithstanding the verdict, and you still then argue lack of sufficiency of the evidence and all that good stuff on appeal. So you have grounds of appeal, but why not give them more? Why not give you more grounds of appeal? It just doesn't make any logical sense there. Where was I? Where was I? It never hurts when I try and do more than one thing at a time. Yeah, so tomorrow, assuming that motion happens at all and they argue over that, then the next thing that they're going to argue over is the jury instructions. So there's been some proposals to revise the jury instructions. So tomorrow they should have the jury instructions finished. So tomorrow's stream from me, if I'm not streaming live, but the end of the day stream from me will be going over the jury instructions in full, because by then they should be finalized, right? So I have been kind of talking around them up to this point because they haven't been finalized. So tomorrow, oh, okay. Okay. Where was I? Yeah, so tomorrow's stream, tomorrow for day 10 stream, we will do a complete going over the jury instructions. So we'll list them in their full detail. I'm going to explain what they mean the best as I can, depending on how the jury instruction for the reckless endangerment goes, because that one is still confusing. So hopefully they'll revise it. We'll go through it and we'll talk about what all that means. Now, one of the other things that the prosecution asked for is for lesser included. So as I was explaining on Nick's stream earlier, what that means is when you have a charge that implicitly includes other charges. So an easy example of what that would be is burglary. Well, I don't know if that's necessarily true. Hold on. Let's say the nature of the burglary is you took a thing, because you can have other kinds of burglary. Okay. So let's say the nature of the burglary is you took a thing from someone's house. Okay. So the burglary includes in it the theft, right? So if you're being charged with burglary, which is you entered someone's house without permission and took someone's stuff from their house, you're implicitly charging them from taking things that don't belong to them, right? So burglary in this context includes the implicit charge of theft. So what you're asking for when you're asking for a lesser included is, I want the jury to be charged with both, right? I want the jury to be charged with both. I have to, in order to prove burglary, I have to prove that they entered the house without permission and they took something. But if the jury doesn't believe part of that, then maybe they can still believe he took something. So because I've already implicitly argued that too. So I'm asking, the lesser included means it's a lower penalty, and it necessarily is a subset of everything that's in the upper charge. So it's included because in order to prove the upper charge, I necessarily prove the lesser charge. So it's included as part of the upper charge. So does that make sense? It's lesser and included. That makes it a lesser included. So he's being charged with first-degree murder. So what might the lesser included be? Well, I don't know off the top of my head exactly what it is in Wisconsin, but lesser included would typically be things like second-degree or other lower counts of murder. They would typically be things like voluntary manslaughter, involuntary manslaughter, or criminally negligent homicide, or even aggravated assault, right? Because you can't have a first-degree murder without an aggravated assault. Right, part of the murder is I assaulted you. A little bit hard to have the murder without the assault. So we're implicitly charging the assault. So depending on what lesser includeds are provided, you might see you're being charged with murder in the first degree, but you, jury, in the alternative can find any of these things. Murder in the second, third, manslaughter, voluntary, involuntary, criminally negligent, aggravated assault, blah, 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 all that stuff, right? So they're all implicit in the murder charge. So they're going to ask for some, but not potentially all these things, to also be charged to the jury. So for any given block, for like the one murder, right? So for the one murder, they can only come back with one of these things, right? They can only come back one of the things. So they can only come back with respect to the death of Rosenbaum, for example, assuming that they're charging with everything, right? So they're charging murder in the first for Rosenbaum. So if the jury's charged with this and the lesser included, that means with respect to Rosenbaum, they could come back with murder in the first degree, or murder in the second, or voluntary manslaughter, or involuntary manslaughter, or aggravated assault, right? These are all alternatives. They're all alternatives, and you can only come back with one of them. And of course, that doesn't necessarily influence any other charge. So you could at least come back with, involuntary manslaughter for Rosenbaum, but murder too for Huber, or, any other combination of things, because all the charges are considered separately. So it's an opportunity for the jury to look for other lines of fault, right? They're all considered independently. So maybe it's only aggravated assault for Rosenbaum, but maybe it's murder one for Huber. Maybe it's only attempted assault for, the Gruber, or whatever, right? They're all possible combinations the jury can come back with. So that's what the lesser includeds are. And again, when we get the actual jury charge tomorrow, we actually have the jury instructions tomorrow, we'll know exactly what lesser includeds are in this case. That means we'll know exactly which ones are being included, and we'll be able to go through them step by step and go through their various elements and discuss what that means and what the jury can and cannot find based on my assessment of the evidence. So hopefully that's all makes sense in some combination, right? So that's basically what's going on tomorrow. And then on Monday, the jury, assuming that the case isn't dismissed tomorrow, which is a likely bet, assuming the jury isn't, the case isn't dismissed, then coming back on Monday, the jury would be charged with the jury instructions. So some states do it in the opposite order. So some states do the closing arguments, then do instructions. This state appears to be one of the ones that does the instructions first. So the jury will be given all their instructions verbally. And thank God they'll be given a copy in writing, because there's a lot of information to take down, and legally dense information at that. So they'll be given a copy of all the charges in writing, along with their jury form that they have to fill out when they're done. Right, so they'll be given that in a packet, and then the arguments will begin, and they each get 2.5 hours per side, as I understand it. So that means that the prosecution will go first. No, typically it's the other way around. Typically the defense will go first, although I don't know how Wisconsin does it, but typically the defense would go first, and then the prosecution would have the last word. And then, so they can alter, and usually the prosecution gets the last word, because they're the ones that have the burden of proof. So they're the ones that get the last opportunity to present to the jury. That's typically how it is in most states. And then after that, the jury will be sent back into the jury room, and then they said they draw lots. So there's still 18 of them, I think, or 17, some of those, something like that. So there's some number of them, and they're going to get down to 12. So my understanding is they're going to draw 12 names out of a bowl, and I think everyone else is going to be sent home, which to my mind seems really, really weird, because normally you'd keep, or I don't know how Wisconsin normally does it, but in many states you'd keep them on, you'd keep them in a separate room, some number of them, in case you need to sub out a juror in the middle of deliberations, because it can happen. a juror can become sick, can become ill, there's a family emergency, we realize the juror is super, super corrupt or something, weirder things have happened. So normally, you keep some of the alternates also, like, somewhere, just in case you need to sub them out in the middle of the deliberations. But if I understood correctly, it doesn't look like Wisconsin does that. So if you lose a juror, then I assume you're done. Incidentally, in federal law, you can get down to 11 and still have a valid jury. There's a rule for it. So you're allowed in federal system. You're allowed. You start with 12, or you can start with more. Incidentally, but if you get down to 11, you can still keep going on. But I don't know if Wisconsin allows for that. So it's just a little FYI on a slight point of federal law that doesn't normally come up. But it is allowed for. Anyway, so, and then the jury will begin their deliberations. They are facing, 6 different charges. And each of those charges now potentially has alternates. So that could be a fairly long deliberation, I think, depending on how much the jury wants to get into the details and all the rest of it. So, that's kind of where we're sitting right now. In terms of the overall tenor of the trial, at least for me, and I think I'm maybe more well-informed than the typical person because I've been following this case fairly closely, but I don't feel like I really learned anything substantially new. There's little details, there's little details that I learned along the way, but nothing in the details really impacted my overall analysis. And for my money, at least, I think everything that you needed to know about this case, you probably could have known, a week after the incident, if not sooner. The videos had been up within hours. The information that was available to reach a conclusion was there, and we didn't learn anything. We didn't learn anything about any sort of antagonism from Rittenhouse or any sort of prior incident that would taint our analysis anywhere along the way. So, we basically had everything we needed within a week. And if you wanted to be a little bit more generous than that, then we had everything when we had the charging document from the prosecutor, because that was the prosecutor's case. And so we knew everything when the information, which is the formal charging document, got done. So, I feel like we collectively didn't learn anything, and I still feel like on the attempted murder charges, I think it's a clean self-defense. I really do. I don't think it's an issue of the defense. I mean, if it were the defense's burden, to prove it beyond a reasonable doubt, I think they're there. To be quite honest, I think they're there even if it was defense's burden, because I just think the evidence is so clean. There's some little, even if you think it's the defense's burden, there's some little nibbles, there's some little moments of question, but on the overall analysis, I think you're there. And of course, that's not the standard. The standard's on the prosecution. So even if you disagree that the defense hasn't proven it beyond a reasonable doubt, even if you disagree with that, I think we're somewhere close to that, and I don't think we're anywhere near the prosecution being able to prove it beyond a reasonable doubt, because it is their burden to disprove it. The law assumes it. The law assumes Kyle has self-defense. The state has to disprove it, and I don't think they did that. So, all those good things. So I think Kyle should win on the murder and attempted murder counts. I think that the self-defense claim is perfectly solid. And, if, as a judge, if the jury came back guilty, I'd be very hard pressed not to overturn that verdict, because I just don't think you're there. So I think I'd I think I would be JNOVing it. I only say it qualified. Well, I say it qualifiedly for a couple reasons. One, I'm not a judge. Two, I don't have the experience of this judge. And three, I think at least for my legal philosophy, it's a trigger you want to be very reluctant to pull. I think it's something you want to be very, very reluctant to pull because you don't want to take it away from the jury. The jury is part of the system, and you don't want to fall into this trap as a judge of thinking that your judgment is better than everyone else's judgment. You're smarter than everyone else. You don't want to fall into this trap of hubris of thinking that you're better than everyone. That's how we got the judges that we used to have in the olden country with star chambers and all the rest of it, where the judges thought that they were, this is kind of like the attitude the prosecutor's giving off, to be quite frank. The prosecutor's giving this air off of arrogance and superiority and some sort of Hunger Games-esque thing of, these are the little people and they are beneath me. And perhaps it's overcorrection on my part, but if I were a judge, I'd be very reluctant to interfere with the process, because we have a trial by jury. That's our system. We have a trial by jury, and I don't want to fall into this trap of thinking I'm more educated, I'm more informed, I know what's going on, I'm just the best thing ever, and I should substitute my judgment for all these peons' judgments. I think you want to be very careful to avoid that as a judge. So I think I'd be reluctant, but I think I'm there because of all the factors I said. So if any of that makes any sense, then hopefully that helps. Let me answer some of your questions the bot has been capturing for us. Wesley said, will a motion for a mistrial be brought, or will we have to endure 2.5 hours of Binger closing as cruelty? Probably both, unfortunately. Bass Boy said, with the prosecutor getting stern talking to about the constitutional issue, he brought up, is that grounds for an appeal later if he's found guilty? Yes, it is grounds, along of other grounds, but yes, Kyle has various grounds of appeal. He has various grounds of appeal at this point. That is definitely not always true in criminal cases, but I definitely see grounds of appeal here. Greg Cote says, why do you think the defense did not get into basic psychological effects that occur during a defensive encounter? As a CPL CCW instructor, we teach this extensively. Yeah, I know. I'm a basic pistol instructor from the NRA myself, and even I know the basics. Why they didn't have someone... That's not even necessarily an issue of a defensive encounter. It's just an issue of any encounter that requires sudden action. Whether that's a car wreck or some sudden incident, it takes people time to react. So why you didn't have someone testifying as to the basic aspects of, this first shooting happened within less than 3/4 of a second, and talk to the jury about things they would understand from their own life, or things they could more relate to, perhaps. So you would talk about car accidents, for example. You talk about other things that are notable that happen within 3/4 of a second. Can you react to that? Or you do something as a demonstrative in the room to show how fast 3/4 of a second is. There's ways to put that together. And I don't know why they didn't have anyone testify. Dr. Black was going to testify to it. Apparently, the defense, for some reason, agreed during the motions in limine to restrict Dr. Black's testimony. And then the prosecution got even more as part of a motion, but why they made that initial agreement, I don't know. Why they didn't have more than one person ready to talk about it, I don't know. So I just think it goes to show that the defense are not very good lawyers, to be quite honest. And this is not the first sign we've seen of this. I mean, Sheriff Vesey is a fine lawyer, but Richards is a horrible lawyer. He's not a good lawyer. He's not a good trial lawyer. Whatever else he might be, he's not a good trial lawyer. And the fact that I can do better in my head is really depressing. When my total trial experience is under 6 cases, you know, and those were mostly, you know, small things for pro bono work that I was doing. It's not encouraging when I'm like, yeah, I can do better than this. Kevin Burns says, why didn't the defense play the video from beginning to end to show how fast the 2 minutes and 55 seconds was? The second by second breakdown was painful. The defense is not very good lawyers. Sonny Fennell says, do you think the defense lawyers will take any advice from other lawyers on their closing? Nope. No, I don't think they will, nor would I expect them to. You have to be careful. Okay, it's not out of a position of arrogance, but if I were the lawyer in this, I'd probably be less likely, very unlikely, to be looking at sort of the daily reports. I'd be very unlikely to look at Twitter. I'd be very unlikely to look at commentary. And I for sure as shit am not going to take advice from anybody. That's not out of a position of arrogance. It's out of a position of I'm the guy. I'm the guy, and it's too many voices in my head, to be quite honest. You know, if I tried to take advice from everyone who was trying to give me advice, I'd go nuts. You know, it's just too many voices. It's too many people. You know, it is in my interest and in my client's interest to just go with my plan. And so I would be very unlikely to look at Twitter, very unlikely to social media, and I'm not taking suggestions from anybody because it's too many voices. You go insane. Joe Smad said, were they not supposed to be rebuttal? Apparently that didn't happen. Jeffrey says, what do you think of the presumably LSAT? I have no particular thoughts on the LSAT. Ben Gerber says, but the prosecution said they plan to also charge lesser includeds. Wouldn't this include manslaughter? Could. And do you believe Kyle could get charged with these? Yes, he could. We'll learn more about what lesser includeds are going to be included tomorrow. Thwarim said, what do you think the prosecution wanted 2.5 hours for rebuttal and closing? I don't know. That's very long. Are they going to, and can they rehash over the video second by second again? Yep. They sure can. It's their 2.5 hours. They can literally go over any evidence they want. So they can go over the videos again, very, very painfully, step by step, and make us all want to, rethink the decisions in our lives that got us to that point. KZ said the defense officially asked for mistrial with prejudice. I don't think they did. I hope they will tomorrow. Noonish said, really crappy day for the defense though. John Black was wasted. Mostly true. Prosecution got to admit those manipulated pictures. They didn't do anything for me though, so it didn't matter for me. And Drew Hernandez was terrible under cross. Fair enough. It wasn't a great day. Sean Thurman says, doesn't a directed verdict need to be asked before the jury reads out their verdict? For a directed verdict, I believe that's technically correct, but so it wouldn't be a directed verdict, but it would be a dismissal with prejudice. So yeah, I don't think you can. I don't think technically you can do a directed verdict after the jury reads its verdict, or the verdict is read out. But yeah, it doesn't really matter as a practical matter. 40 going west. Do you ever get brazen with your judge or your boss? Occasionally, my boss. Maybe wag your head at their response to a question, or maybe leave the courtroom time and time again to savage the snack machine. There have been days when I've wagged my head at my boss, to be sure. Methrin Nathan, Kyle's lawyer did ask for a mistrial by prejudice yesterday. I'm not sure he did technically ask for it. He said he was going to ask for it. I'm not sure he technically asked for it. His number 2 also said still has the motion open today. Remind the judge. The judge said so he's still considering it. Maybe that's true. Maybe they did formally ask for it, but that wasn't my understanding. Joe Central, oh. Well, let me rethink that. The judge did treat it as being made, so maybe they did formally make it. I'm a little bit confused on that aspect. Hopefully they'll renew it tomorrow either way. Joe Central, oh, says, what legitimate points are there against Kyle? You have to make a lot of assumptions to, you have to not necessarily make a lot of assumptions, but you have to make a lot of conclusions that don't appear warranted by the evidence. So here's how you get to, I think your easiest one is Rosenbaum. Your easiest one is probably Rosenbaum. So here's what you have to conclude, or here's a way to conclude that Rittenhouse is guilty of murder of Rosenbaum. So here's a path to get there. It would be probably very helpful for you to be able to conclude that Rosenbaum did not in fact threaten Kyle, that Kyle did not in fact hear it, that Kyle in fact did not remember it, or Kyle in fact did not recognize Rosenbaum when he saw him later that evening. Remember, you're the trier of fact, remember? So you get to determine what facts are now. It's great. So it would be very helpful if you could reach one of the following conclusions of fact. Rosenbaum did not, as a matter of fact, threaten Kyle. Kyle, as a matter of fact, did not hear it. Kyle, as a matter of fact, did not remember it. Kyle, as a matter of fact, did not recognize Rosenbaum. So if you can come to one of those four conclusions, then you could come to the conclusion that when Rosenbaum was chasing Rittenhouse, he was posing a non-lethal threat because he was only chasing him, and he only had a trash bag or a hospital bag which he had already thrown. So that was no longer a threat in any case. And Kyle himself testified, somewhat foolishly in my opinion, but Kyle himself testified that he did not believe the gunshot came from Rosenbaum. He said that. That was a mistake. It would have been much more helpful if he had said, I'm not sure where it came from. I thought it might have come from Rosenbaum. But he's already excluded that possibility. So he knows the gunshot doesn't come from Rosenbaum, so you can't use that. So now you would say, okay, Rosenbaum is posing a non-lethal threat to Rittenhouse. He doesn't have a gun, he doesn't have a knife, he doesn't have a bat, he doesn't have a chain, and so forth and so on. He's merely trying to run and chase him down. But that itself can't be perceived as a lethal threat, surely, right? Merely someone chasing you without any kind of weapon surely can't be a lethal threat, can it? So then you say, okay, well, Rittenhouse pointed his gun at Rosenbaum, and that itself is lethal force. You're pointing a weapon, deadly force, you're provoking the other person. It's provocation or use of deadly force, probably both. So now Kyle is the first bad actor, which means that when Rosenbaum attacked him, Rosenbaum had valid self-defense and Kyle Rittenhouse didn't. So if you believe all that, then Kyle Rittenhouse is guilty of the murder of Rosenbaum. That's the best way I got there. So you have to reach what I consider to be a series of very improbable conclusions based on the evidence. But so that gets you to the murder of Rosenbaum, and that is probably the best case for the prosecution. $40 going west, like my new Harris Bingers and the Round Man. Okay. TRS 80 Fan Club says, do you think the mob will attack the judge or jury after court is over? And does that have an effect on jury? No, I don't think so. And as the judge pointed out, attacks on judges and juries are unbelievably rare. Jim Salata says, I was shocked after the same expert testified a few days ago. He couldn't enhance the photo anymore without distorting it. Then they let him do it. I don't know what to tell you. Ben Gerber says, what about the prosecution having proved lesser included charges, manslaughter? What's your perspective on Kyle being found guilty of lesser included? Well, I haven't really considered them in depth, to be honest, because it wouldn't matter. Because if Kyle has a valid self-defense claim, it would be valid self-defense claim for all the lesser includeds. So I haven't really considered the lesser includeds because I think he has self-defense and it would permeate through. It's not like he has self-defense. It is not possible for him to self-defense for the murder, but not have self-defense for the underlying of aggravated assault. That doesn't make any sense. Sean Thurman says, with dismissal with prejudice, would the judge ever say, I won't grant that, but will dismiss without prejudice? I guess they could say that, but Joe Central says, what legitimate points against Kyle? I answered that question. And you asked the same question twice, Joe. The thing says, just ask it once. The bot's got you. Joel says, can it get thrown for the prosecutor's an asshole? No. Tom says, do you think the prosecutor intentionally tried to get a mistrial, like a do-over? The judge seems to think that. The judge already said he thought he was bad faith, so it seems like it. Trespassing is a classic lesser included burglary. Better example, Joes. Thank you. Yeah, trespassing is a better example. Trespassing is lesser included. You can't commit burglary unless you're trespassing. Much better. Thank you, Joes. KZ said, would a lesser include be something like deadly conduct instead of domestic violence? I don't know enough about your domestic violence or deadly conduct to comment. Tom Forsythe said, how did George Floyd convict on all 3 charges for 1 death? Because of the way that Minnesota's instructions are written, they're really, really weird. And 3rd degree murder is not a lesser included of 2nd. So that's how. Richard M. says, is the prosecutor asking for this as a sign the prosecution's worried about their case? Yes. Yes, very much so. By giving the jury the option, they're giving them the ability to make a compromise verdict, and something is better than the nothing they're looking at. David Young says, do you think the issue with the rifle raising prior to Rosenbaum chasing the defendant will topple defense's entire case? Only if you believe all the things that I had said earlier. Kevin Burns says, Massachusetts versus Woodward is the only time I've seen a verdict set aside by a judge. Extremely rare. It's pretty rare. It's definitely not the only time. It's not that rare, but it's rare. I'm not sure what the percentages are. Swenson Bailey said, if the judge were going to dismiss the trial, why not already dismiss it? I told you. Because if the jury does it for you, that justice is done and seen to be done, right? It's better because the jury verdict is one that the public is more willing to accept. So if you get it from the jury, great. You've got something that they are more willing to accept, and that's a plus. Someone is trying to spam me in Discord. That's fun. Marjorie says, I think if the jury returns a guilty verdict, the judge will rule because of undue influence in order to avoid appeal. I don't think the judge gives a damn about appeal. I can tell you I don't give a damn about appeal. As in my job, right? I don't give a damn about appeal. I make the decisions I make, and I really don't give 2 rats ass about appeal. When I'm making the decision, I don't think about it. Like, if the appeal comes, the appeal comes. But it doesn't change my decisions in the moment, right? It's like, I'm just going to make the best. I don't worry about it. It's like, I'm doing a role. I'm doing the best I can. I don't worry about it. I seriously doubt the judge does either. The judge doesn't give 2 shits about being appealed. Why would he? It doesn't matter. Propter Hawk says, do you think there's going to be court broadcast tomorrow? I don't know. Sean Thurman said, Pross is going first, then defense, then rebuttal. Okay, fine. Ryan Millman says, how are you and the other panel feeling after today? Seem to go more prosecution today for first. The prosecution had a better day overall. Swenson Bailey said, ginger power. That's very nice of you. Ben Gerber said, how could Colin be found not guilty on some of these lesser included charges? Not be found guilty on some of these lesser. Oh, okay. Well, because the state didn't prove its case would be the reason why. I think I've missed some super chats, so let me go back in time and see if I can find some of them. $5 from Pastor Flash. If I take another still frame of that drone video, blow it up, and say Colin never raised his gun, did I do it right? Does that prove Benninger wrong? Apparently the way things are going, my friend, yes, they do. Let's see if I can find the other super chats that people have asked in the past. I have to go into the back end, but there's a way for me to do that. Hold on. I think. Yes. This is from yesterday, though. Or no, these are from yesterday. So it doesn't have super chats from today on my back end. That's annoying. Oh well, I'm sorry guys. I try to keep up. Where was I? Thank you for the super chats, by the way. Usually the prosecution's first in making a closing, then the defense. The prosecutor's burden of proof has the last chance to respond. I think that's right. I think I screwed up. 40 Going West says, what's your bet over under on the wise on the jury deliberations? Say 2 days or 16 hours. I think it said record for shortest ever, so I'm going with under. Could be. Nicholas Sean says, how do we come to the idea of a 12-person jury? Oh, that's just old as dirt. It's just old as antiquity. $10 from Joshua Sanders. Do you feel like if Kyle's convicted, the mob rule is here? We need better laws to protect the jury and possibly keep media out of the courtrooms. Well, keeping media out of the courtrooms altogether is a non-starter because of the right to a public trial. But better laws to protect the jury, sure. For the 2,300 of you who are currently watching, I really do appreciate you being here as always. And I hope to answer your questions, and thank you for being here. And I'll try to give you as much intelligent commentary as I can. Please remember to subscribe if you've not done so already. I would very much appreciate it. Rostus Android said, seems odd the prosecutor can swipe in at the last minute and add more charges after they see how the trial went. Yeah, they're lesser included. So implicitly the charges were there the whole time. So implicitly by charging murder in the first degree, you're charging a whole bunch of other things implicitly. So it's not unfair because the defense has notice of that. You know, it's in order to prove murder in the first degree, you have to prove a whole bunch of other crimes implicitly. $5 from Andrew Callaghan. What are the best grounds to appeal a guilty verdict? A lack of sufficiency of the evidence. No reasonable juror could come to these conclusions. On the reckless endangerment charge, that the jury instruction is ass backwards. Also, that reckless endangerment doesn't make sense as a matter of law. And the gun possession charge doesn't make sense as a matter of law. So those are the best appeals I see. Wolverinar says, why is the state allowed to add charges at the end when the defense had no chance to defend against them? They did, because they're implicit. They're implicit. The defense knows about this. This is not like a surprise. Me Hammered says, I learned prosecutors are slimy bastards. They sure can be. Kevin Kennisdal says, when will we hear arguments for dismissal due to prosecutorial misconduct? I'm not sure if we already have or not, but presumably we'll hear more on it tomorrow. New Lexicon says, do you know how much the images are scaled? No. Defense could bring up how many pixels in the image are process of interpolation. I don't know the answer to that question. I couldn't tell a difference between them. Curdy Tank says, why are we waiting for mistrial? I've answered that question. Jack Lamb says, if he does get a guilty verdict, will there be grounds of appeal because of prosecution's inadmissible statements? That too. TurneyNet, $10. In self-defense training, it's commonly taught that brandishing a weapon to discourage a person from continuing being aggressive because it's better off to scare them than to kill them. Yeah, but brandishing is still illegal. And it's an aggravated assault unto itself. So that's probably a bad idea. Brandish, and also you shouldn't point a gun at anything you don't intend to destroy. So I'm not sure who taught you this in self-defense training, but this seems bad from a number of reasons. Kyle Cowden says, some of my favorite racket streams are when you're there for back and forth. Just found you and subscribe to your channel. God bless. Thank you. $2 from Jake Page. How many votes does Kyle need to win? To win? 12 out of nothing. 12 to nothing. Yeah, well, it depends what you mean by win. I mean, to win outright, he needs 12 to 0. To get a mistrial, he needs 1. If there's a mistrial because of jury hanging, then they can retry. So it depends, I suppose, what you mean by win. Johnny Face says, can every mass shooter claim self-defense for each victim after the first should Kyle prevail? No, of course not. That's dumb. Ben Gerber says, prosecution was hoping this case would turn into the new OJ Dream Team. It did not. Furnace Wolf 007, would you take up the case with you, say you and Barnes or someone else doing it? Sure. I'd work with Barnes. That'd be fun. Sean Thurman said, if the defense brings up dismissal with prejudice, can the judge say no? I'll give dismissal without prejudice, even if that's not what the defense wants. Is there just yes or no? I'm pretty sure that they can't. Well, that's not technically true. I'm pretty sure the judge can sua sponte issue a mistrial without prejudice. So I think the judge can do anything they want. Revolt Power says, how long do you have to win a gunfight? The rest of your life. Cute. Christian Temple says, I apologize if my message was mean or unexceptional. I'm a new subscriber and unaware of the rules. No problem. We learn through the misfortunes of others, Christian. Supreme Court implications of appealed. You mean the Supreme Court of Wisconsin? Couldn't say. You mean the Supreme Court of the United States? 0. There's no federal law here that's in play. No new federal law to be had. The issues of federal law are well established, and the Supreme Court doesn't grant cert merely for misapplying law that's already on the books. So if you mean the Supreme Court of Wisconsin, I don't know. If you mean the Supreme Court of the United States, zero. Raymond Muller says, isn't there a state law in subsection says if a defendant is a minor, the jury has to decide if 17 child reasonably believed in danger? I don't know. That would be in the jury instructions, which I assume we'll get tomorrow. Mike Partridge says, why do you think the judge didn't immediately call the case? I answered that. Ruth Shamelin says, just joined, so I'm not sure if you covered this, but why do you think the prosecution's new evidence would be enough for a jury to convict on this alone? No, I think the new evidence is bullshit. Ryan Holiday says, would the judge ask to speak with the jury to determine how they came to a verdict? No. Danger, Will Robinson, danger. No. You don't ask the jury how they came to their verdict. That is just a no-go. That is just a no-go. You don't pierce the veil of the jury. No, you don't do that. That is a big fat no. Riley Hayes said, 10 Canadian dollars. Is anything questionable regarding the gun charge, since they're trying him as an adult, but charging him with a crime that's predicated while not being an adult? Well, no, not in this respect. They're fine. Wait, so you're saying if 11 out of 12 people vote innocent, that isn't enough? Technically, it's a vote of not guilty, but yes. One person could just troll everyone? Yes. If it's 11 to 12 guilty, that is not enough. If it's 11 to 12 not guilty, that's not enough. 11 to 12 guilty means a mistrial for a hung jury. 11 to 12 not guilty means a mistrial by a hung jury. To win, you need 12 to 0. Carol King says, are any TV law shows you deem realistic and watch? I think the closest for me is Law and Order, but it has massive problems too. Matthew says, could you call the prosecutor and ask him about his training as a police officer and use of force? No, but hilarious. Benedict says, could the judge be dismissing the jury till Monday to be a chance to determine whether he wants to go directed verdict? Maybe that's what's going on. Carol King says, when politicians blame judges' bias for an outcome they disagree with, this is more often just a lazy excuse than actual biased judge. I don't know if it's more often than not. There are some bad judges out there, but depends how reasoned they are. It's a little bit hard to say in the abstract. Isaac Wicks says, if Richards would take advice from Twitter, his closing argument would be, well, you see, my client is a white supremacist domestic terrorist. I'm pretty sure that's too argumentative even for a closing argument. Oh, Richards? If Richard did it, that would be malpractice. Daniela says, I've seen Grosofsky make faces at Richard's bad questions. Matt says, why hasn't Binger been held in contempt of court yet? Good question. Thomas Ligens Jr. says, the verdict is not guilty, and supposedly peaceful demonstrators riot and try to burn the city. Do you think it's National Guard time, real time, kicking butts and taking names? Sure. On the last evidence, the judge submitted it was subject to cross. What does that mean? I don't know what that means. Yeah, it means it's submitted. I don't. Yeah, it's submitted. Have you researched the case of United States versus Lesko Brandon? That's hilarious. No, I have not reviewed the case of United States versus Lesko Brandon. But my limited understanding of Lesko Brandon is the proposition that Joe Biden is a tool. I seem to remember that in a footnote somewhere. Johnny F. Face says, all hail the large brain custom hat club. Cheers. Thank you. Your wife's son, do you think putting Rittenhouse on the stand was a good idea? No, it was not a good idea. It was a bad idea. Putting Rittenhouse on the stand was a bad idea. Bad idea. I don't think it hurt the defense too much, although I did think it probably hurt them a little. The biggest problem is the crying thing. There was a great line from Breaking Bad where Mike Ehrmantraut said, when someone has a gun to their head, everyone is Meryl Streep. Right. I don't know if how many of you watch Breaking Bad and remember that line when they talk about Lydia and her good acting, right? And Jesse Pinkman says, oh, I believe her. And Mike Ehrmantraut says, kid, when someone has a gun to their head, everyone's Meryl Streep. It's like, yeah. So how they responded to the crying thing, how they responded to the admissions, I don't know. It's a horrible gamble. I don't see any upside. I still don't see any upside. The only sides I see are downside. I don't think it hurt Kyle too much, but there's no upsides. It's horrible. Maybe some of the jury will think he cried his way into a conviction. Drew says if there's a mistrial, can they change prosecutors? They sure can. And they also can change defense lawyers. Both would be advisable. James A says, don't you think if Kyle would get off with a slap on the wrist, it will cause an influx of people practicing vigilante justice? I don't think that's an excuse to, I don't think that's a reason to not give justice now. Korg is in horses. If 11-1 not guilty, would the retrial less attractive? It depends what they're trying to accomplish with it, to be honest. Raul Hayes says, is there anything questionable in the gun charge about trying? We read that. Scorpion 142, is dangerous weapon charge possession bunk? In my opinion, yes. I don't see how the judge's reading of the law makes sense, but that's my view, and the judge disagrees with me. Metal Man says, do you think Kyle's innocent? Well, I don't know what you mean by, well, strictly, I can be a real ass in response to your question. Do I believe Kyle is innocent? Well, strictly speaking, I know for an absolute fact he's innocent, because he's innocent until proven guilty. That was my ass answer. The real question you're asking me is, do I think he's not guilty? And the answer is yes. Given the legal standards that are in play, I think he's not guilty of the crimes charged. I think he has a rock solid affirmative defense. Flab says, do you think the prosecutors are trying for mistrial? The judge seems to think so, and I do too. Skronk Finkel says, what happened at the end procedurally when the prosecution dismissed the expert witness, then showed pictures available? Don't they need a witness? Nick, the panel missed this point, and I didn't want to correct them. But what they were doing at that point was technically called publishing to the jury. So when you offer evidence to the jury, if you want the jury to actually see it, you actually have to publish it. It's a weird rule. It's a weird rule. So evidence can be part of the file, but if you want the witness to actually, if you want the jury to see it, you have to ask for permission to publish. So they brought the witness off the stand, and then they said, "Can I publish?" Well, at that point, it's just a formality. That's just a formality. The defense did the same thing, incidentally. At the end of their case in chief, they published some things. I don't even know when they offered them. Right? So they did the same thing at the end of their case. They published some stuff that they had forgotten to publish. And the same thing was done. So they were publishing it to the jury. So the evidence had already been entered and testified to and shown to the jury, but it had to be formally published. It's a weird technical thing. Don't worry about it. Can the judge dismiss with prejudice sua sponte? Yep. Benjamin Jeffrey says, do you think the prosecutions will use social media to aid them? Sure, of course they will. I Am Spaz says, do you think Kyle will face a minimum of 1 year in jail time due to the minor in possession? Since the judge dismissed attempts to drop it twice. If that's the worst that he gets, then sure. Do you think the judge will rule on the minor in possession because they've already had jury instructions? As I understand it, they've ruled on it twice, but they're looking at rewriting it or fixing it or something, so I don't know. Rust Us Android said, if Kyle's found not guilty and Kenosha is inflamed in riots, maybe Kyle can get back out there to protect things. Wouldn't recommend it, man. Connor Driscoll says, your thoughts on the viability of a civil suit against Groskowitz for assault given acquittal of Kyle? I'm sure they'll sue each other. It'll be hilarious. Morgeson said, I've watched 3 trial movies. I'm qualified to be a prosecutor in Kenosha. Yep. Your wife's son. Would Rittenhouse have grounds to sue MSM if ruled innocent? Not guilty is the word you're looking for, and I think it's really tough. Ben Shapiro is of the opinion, apparently, that this is a rock solid. I don't know, man. I don't know. It'll be tough. It's a tough civil suit for defamation. Mira says, do you think that will make provocation argument on the basis that Kyle made the line and say pointing the car at the jumping car guy? I'm concerned with that seed being planted. That isn't provocation because it's too far disconnected in time. If you mean pointing at that guy in and of itself is provocation sufficient, then no. If you mean that shows that he was provocating later, then yeah, they could make a big deal out of that. Revolt power, disparity force. He was bigger, older, stronger. I couldn't buy that. Christopher Baker, watching Binger gives me plenty of hope. I'll pass the bar in July. Kyle says, could the judge not save a directed verdict against Kyle as the case appears to be weak at best? Oh, serve? Yeah, they could. Mirror says, why courthouse was not under extensive security measures like the massive presence of law enforcement and National Guard? Are we going to see it on Monday? Probably not Monday because the jury probably won't come back Monday, but we'll probably see increased police presence when they come back with their verdict. The truth, Rosenbaum threatened to kill Rittenhouse does not play a factor into Kyle's defense. It sure does. Pirate Fan YT, why did Kyle take the stand? That was dumb. I agree. His lawyers apparently thought it was a good idea. Mama Mia says, do you feel the judge has shown some bias towards the defense? Not in my opinion, no. I think the judge has been very, very fair. In fact, I've been disappointed at times that he hasn't made rulings, even though he seems like he's going in a particular direction, and then he pulls back at the last minute. Drew says, what about suing Biden for calling him a white supremacist? I don't think calling someone a white supremacist is an actionable defamation. I think that's an opinion statement, not fact. If you said that he was a member in a white supremacist organization, then yeah, but if you're just simply saying someone's a white supremacist, I'm not sure that's a factual statement or factual claim. Joe says, have you seen all the theories about another guy dressed very similar to Kyle who's provoked by Rosenbaum? Why wasn't this pursued? Couldn't speak to that. I suppose it's not a very good theory. Or the defense sucks. Take your pick. Do you think Kyle taking stands overall hurt him or helped him? I think it was a slight negative. Why did Kyle take the stand? I answered that. Didn't it show in the video that Kyle didn't point his video at Rosenbaum only after he grabbed the gun? No. Kyle pointed the gun at Rosenbaum before he grabbed the gun as he was being chased. Mirror said, why was the courthouse not under extensive protection? Don't know. How long think will a jury will deliberate for? Can't say. Anna says, even some alternative universe, Kyle pointed at Zeminski, which he didn't. Wouldn't that fact be retreated enough to show Joseph Roman shouldn't have pursued him? He was pointing while retreating, so that, yeah. Joseph Sanders says, do you believe if Kyle gets convicted, mob rules here? We need ways to, I answer that. Is there grounds to sue him civilly? Who? The law will, if they do convict on reckless endangerment, care to guess the penalty, Judge? It's a maximum of 12 years, 6 months, and I'd imagine a higher end of the sentence spectrum. Morrison said, if there were roof Koreans present, would this never happen? Don't know. Greg Markachan, did the prosecution ever prove reckless endangerment of Richard McGinnis? I don't seem to remember any fact present to point to it. I don't understand the entire theory behind reckless endangerment, really, and if we do the jury charges tomorrow, we'll have a lot more to go with. Thank you for the 2,100 of you who are still here. I'm going through your questions as much as energy and time allows. Mira says, KZ said, I don't think that mistrial without prejudice is on the table given Schrodinger's bad faith comment. He could dismiss without prejudice for other reasons. Mira said, do you think Kyle's friend is getting a deal now? Yep. The Truth said, thank you for asking our questions. You're doing yeoman's work. I'm doing my best. Andy said, are there any arguments or points you'd make that you're the prosecution or defense hadn't? No, if I were the prosecutor or defense, I would have asked different and fewer questions all around. What do you think of someone having to explain pinch and zoom to the judge? They were explaining it on a technical level in terms of what it does and does not do technically. So I'd want explanation of it, and I have a computer science degree. For the record, Haas had said, have you seen Good Morning America of Gage's testimony? I've not. Kyle said, the judges was vocal about transparent trial. Do you think that's maybe why he's reluctant to pull the trigger? I'm sure that's part of the reason. Dimitri said, what happened to McGinnis's video he recorded of Rosenbaum shooting? There's numerous videos of him recording, but that video isn't available. I don't know. You have to ask McGinnis. Ryan says, why did you want to become a lawyer? I'm considering becoming a lawyer, but I'm 27. Wouldn't it be logical just to do it? I want to become a lawyer because I was fascinated by law since middle school. I've just found it a particularly interesting subject. I've been just fascinated by law. I picked up a copy of the Constitution. I was fascinated. Joseph Stein said, how many times did the defense object during prosecution's closing? Oh, probably none, if you had to imagine. It's also considered bad form. $5 from innocuous remark. Hey, buddy, hello. $5 from Norge44. Hobby wants to know if the jury can ask for physical evidence in the jury room to examine it. Oh yeah, yeah. If they want to examine the AR, and they can get both ARs in there together, and they could reenact the scene. Boop, 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 boop. Yeah, they could do all those things. Also, apparently, and I'm not sure 100% how this is possible, but the Glock has apparently a fully loaded magazine still in the box, and they're both technically evidence. So I guess technically speaking, that means technically speaking, that means that they can ask for the Glock in the box with the magazine. They can load it and they can start shooting each other. Excuse me. The king of... Excuse me. The king of casual says, it seems Kyle's case went better before defense went. Yeah. N. White says, is Binger the best lawyer Kyle is working for him? Definitely at parts, yes. Solid Broily says, if Kyle loses the case, how's that vote for other self-defenses in the future? It doesn't have any impact on our self-defense cases. If Kyle loses this case, it's because his defense lawyers suck ass. DR says, not sure if this is addressed. In your opinion, is this long or short jury deliberation? A short jury deliberation is usually a better sign for the defense. It's just, a short jury deliberation is usually better for the defense because it's thought to be very, very difficult for the jury to come to a conclusion of guilty given the amount of evidence, especially in a case this complicated. So if they come back with a very quick verdict, it's favorable to the defense as a typical rule. Jacob said, unrelated, but what's your thoughts on the FBI leaking their raid? I have no idea what you're talking about. I didn't see that article. Imperial Truth says, if it wasn't being streamed, you think the prosecutor would have attempted the same stunts? Probably. Do you think the judge wants to go on appeal? Why would he? He can just fix it now. Propter Hawk says, cheers. Can the judge issue a directed verdict after a hung jury? Yes. Yes, he can. Yeah, he can issue a directed verdict after a hung jury. It's like, how about not a hung jury? Can the defense still introduce new counter witnesses? No, that's over now. All witnesses are done. That's why the case, my friend, is closed. The title is not clickbait. The case is closed. No new witnesses. Zafal says, how'd you avoid getting criminal lawyers like Kyle picked out? Seems like a circus with little preparation. I mean, I'd look at AVVO for ratings and interview a couple different lawyers and, you know. There's a second part of self-defense, great bodily harm. Rosie the pedo may have been short, but he was stocky and kind of built. I don't know that that's necessarily where you want to go with that. Swinger says, do you think the image enlarging is hitting on a larger issue with how loosely digital evidence is being used? I don't know. When was the last time a judge made a GNOV over the jury's decision? You mean ever? I'm sure it happens every day somewhere. In Jim and 44032. I'm confused how a judge wouldn't call the victims. What's the opinion? I think it's the right decision. Whether or not they're victims determines them whether or not Kyle is a bad actor. $5 from $5 from Clown World. Can defense lawyers be subpoenaed if there's a mistrial? No. Attorney-client privilege. Swinker, I was astonished that the Glockenspiel with live ammo was allowed in the same room unsealed. Who thought that was okay? I don't know. $5 from Pineapple Prime. I cacked at the jury Glock comment. Here's a few bucks. $5 from Innocuous Remark. Get some rest, buddy. I'm not gonna get rest as long as you guys keep giving me super chat money. I will. What's the word I want? I will grift. I'll grift for the super chat money. Do you think Kyle will get time served as convicted on lesser charges? No, he's facing too much time. Brent Palmer says, it's just me or is the trial Or is it the trial isn't over? Discrepancy of evidence, but the AR-15 is more dangerous or deadly than any weapon or physical assault. It might be over that. I mean, it's definitely over that to some people, I'm sure. Big black gun scary. Uncivil law. How does someone not with a BFA in photography not know that red plus blue equals purple? Red plus blue equals purple? $1.99. $5 from $5 from Andy Sorrell. Do you think the families go after Kyle Uncivil? Yes. Could you opine on how that might play out? I think he's got it rock solid, man. $5 from Stotch. How long was the Chauvin deliberation? And was it fast for a guilty verdict? I don't know, but the Chauvin jury had a lot less to consider, all things considered. So I don't remember how fast it was. I don't remember it being super fast, though. Hassid said sleep is for the weak. $5 Canadian or 5... whatever. From Andy Riley. I must have missed my chat about outdoor band. Have a great night, and thank you for the work you do. Yeah, I'm sorry, Mr. Chat. I do have an outdoor band. That's why there's music playing in the middle of the stream with Nick. Because, yeah, I've got an outdoor band here. What's a directive verdict? Directive verdict is just where the judge directs the verdict. The judge just says, here's the verdict. That's what it is. It suggests that someone needs to testify the video captures true depiction. Does that mean surveillance camera footage can't be admitted as evidence since no one's there? No, it doesn't mean that, because you just need to be able to show the surveillance camera footage itself is not been altered and is correct. It's not a problem. Do you think the prosecutors are going to have any repercussions? No. Did you get a chance to watch Nate debate with Bess? No. Johnny says, could mass shooters more evenly claim self-defense of all victims after the first shot should call reveal? You asked that question, and no, that's a dumb question. It's a dumb question, Johnny. Holy God. I don't understand why you'd ask a question that dumb unless you are dumb or you're just trolling. Could mass shooters more easily claim self-defense on all victims after the first should call prevail? That is a dumb question. No, there's kind of some interesting differences between the two, Johnny. Try not to ask questions that are dumb. Your teacher might have told you there's no such thing as a stupid question. Your teacher lied. Mr. 9x19 said, wouldn't the doctrine of necessity or doctrine of competing harms be able to exclude reckless endangerment? I would think the reckless endangerment thing doesn't make any sense to me. Isaac says you're a really great straight man for Nick. Well, I do what I can. Lucifer himself says, if I'm a defendant and wish for a private trial, can I have a trial without media? No, because it's also considered a First Amendment issue. TRS 80 Fan Club. Did you know this is similar to other historic events that will be remembered and resulted? Everyone will remember you. Hit that like. I hope they remember me. As Kyle himself, Mr. Four Doors, Miss Morehorse said, just trying to be famous, man. Just trying to be famous. Kyle, wherever you are out there, cheers to you, brother. If a mistrial occurs, would you ask for a bench trial the next go? I don't know, man. Scotch says, no such thing as a stupid question. Is it snowing outside? Visibly snowing. Yeah, I feel like Stephanie, our resident OSHA person, could tell some stories about stupid questions. I'm sure. I'm just going. I don't know for sure, but I'm going to take a guess that OSHA, our safety person, has been in a situation where there's a piece of machinery that says something like, "Don't touch big red button." And someone has asked her while they're both standing there, can I touch the big red button? And then Stephanie beats them to death. Yeah. Johnny Foss, apologies for the dumb question. Drew gave me $10 Australian. I was hoping defense would burn their witnesses that Binger pressed about the tweet and asked to submit evidence. As prosecution has raised it first. Someone asked, is the female cop married? Well, my friend, you know her name. You know where she works. Feel free to send her a proposal in the mail. How long of a deliberation is a hung jury called? It's not. The jury has to give up first. So the jury, if they want, they can deliberate forever. The jury has to give up first. In terms of how long do they have to deliberate before the judge will grant it, the judge is likely to send them back at least once to deliberate. So they're probably not the first time when they ask, unless they deliberate a couple days already by now. Ooh, Stephanie says, I could give you examples, but care more about packing for my date. Ooh, Stephanie, that sounds interesting. Who are you going on a date with, Stephanie? Are you afraid of YouTube comments yet? I'm trying to learn not to care that much. John says, gives me $1.99, says, my defense for all the dumb questions is I was hacked. Jacob says, what kind of apple juice is it? Also, Binger is a tool. Today's apple juice is pecan praline. Let's see. Were we? Put a pic in your Insta and you'll know. Hold on. Oh, Lord. Let's see. Mitova says, if the appeals court of Wisconsin doesn't overturn a possible guilty verdict, is there a chance for it to go to the U.S. Supreme Court? No. Swenson says, what's your favorite Binger meme or joke? There's a lot of good stuff there. In some states, 11 not guilty can be enough to be not guilty. I think there are 2 states that do that. Well, there used to be 2 states that did 11 to 1 guilty was enough for guilty, but I don't know about the reverse. So you might be right, but I wouldn't swear to it. Science works in mysterious ways. Hi, I've heard 2 versions. Can you explain the difference between a mistrial with prejudice, and a dismissal? So a mistrial just means something bad happened during the trial and we need to stop the trial and do a do-over. With prejudice means we're not going to do a do-over. Dismissal means the charges suck and we're dismissing the charges. So dismissal means the charges go away. Mistrial means a bad happened during the middle of trial. And with prejudice means a bad happened during the middle of trial and go away forever. And that's the difference between dismiss with or without prejudice. Prejudice literally means prejudge. It literally means prejudge. In the same sense when we talk about like prejudice when it comes to like race or something. Yeah. When we say that you're prejudiced, what we literally mean is it's prejudged. We've prejudged it because we've already heard the case in this instance. So it is prejudged to go away. We don't care what you say. We don't care what you argue. It's all crap. I'll take an air photo. Oh, my photos are just great. The greatest photos ever. Propter Hawk says, is Binger completely evil or just 99.9%? It's pretty bad. If it's possible for unanimous decision on certain individual charges, would split the decision on other. Would that result in a hung jury? No, it would not. If the jury is able to come back with a unanimous verdict, then those unanimous verdicts with respect to the ones they come back to would be unanimous. So that's fine. If it leads to a mistrial by a hung jury, does the judge then decide with or without prejudice? A hung jury is without prejudice. You'd have to decide with prejudice for other reasons. I think Richard might play the entire 2 minutes 55-second events near the end of closing. That would be competent. KZ, so I would not depend on it. Clownword says, if there's a mistrial, can the defense lawyers be subpoenaed? Nope. Where was I? Zafal said, what do you think of a game idea set in Kenosha where you can play a character in a riot and you have to deal with how you'd react in a simulated court? I don't know, man. I seem to be losing subscribers rapidly. I'm down to 1,600 concurrent subscribers. Where were my other 600 subscribers, man? I've been answering your questions. Where did my other 600 subscribers go? I'm losing subscribers. I'm losing viewers rapidly. Don't leave me, viewers. If you leave me, I won't answer questions anymore. I'm not trying to bore you. Base Knuckle said, would you give an opinion on the FBI stealing Project Veritas's material and turning it over to the New York Times? I don't know anything about it, so I won't comment. Topo Musical says, do you agree the video's expert testimony on Cross? The defense should have immediately moved to enlarge the pics withdrawal since they may not represent reality. That was a weird thing, man. The whole thing was weird. Red QWERTY U says, are the rules of court that a lawyer can break the judge hates but are not illegal? Probably. I mean, there's basic decorum stuff that I'm sure that you could technically break, but all right, where was I? How the delayed Detective Flusterbinger regards the AR-15? I don't know. On Science Works in Mysterious Ways, for the record and chat, I can't tell how much I appreciate all the law people weighing in. Thank you. I appreciate it very much. John F. Face, not personally pro-cop, but these prosecutors own gold hard. Yeah, I think I could have done better. Duck Pawn says, do you think Kyle would have a good defamation case against media? Probably not. Topo Musical, we answered that question. Jared said, you make me want to pour a drink. Pour a drink, Jared. Justin says, if mistrial, can the state drop charges? Yes, they can. And will they? Probably not. Propter Hawk says, appreciate what you do. Mad Mud Eye says, do you think Gage should be charged on unlawful concealment? Yeah. And attempted murder. That'd be good. Aggravated assault. Cthulhu alone yet will waken. If you want to see Artifact Edition by Algorithm, look above the sign in the enhanced version. Connor says, with regards to court holding in Let's Go Brandon, I share the proposition that Biden isn't a tool isn't just dicta. Warrior King Chris says, can the judge rule Kyle be tried as a minor at the end? No. Matthew says, thoughts on upcoming wrongful death lawsuits. In the Astro world, if I ever find time to cover them, man. Or did you mean this case? Either way. VPB says, they mentioned the beginning about witness being impeached Colliver being a student at ASU. That didn't happen because the witnesses weren't called and the case is closed, so that didn't happen. Marcus said, something needs to be done about presenting evidence in slow motion freeze frame. Probably. Challenge 100 round shoot off at $1 a round. Come on, man. Aaron says, I'm the only one who knows how Lefty was going for double grip on his pistol before he got bicep blasted. Yeah, as a matter of fact, I didn't notice, so I'll take your word for it. TTM says, since we don't know the age makeup of the jury, how likely is it anyone can predict the outcome of the trial? I don't know. I comment on the rumors the prosecutor was angling for a mistrial. Do I think the judge has been too harsh with Binger? Not really, Nigel. Marcus said, better fire control target acquisition marksman than most soldiers. True that. Astro GK says, what's the likelihood a jury won't see sidebar prosecutor beat downs on social media? Well, they're not supposed to look, so surely they won't, right? I was up to 2,400 for a while. Yeah, I was up to 2,400 a while, and now I'm up to 1,400. Where are my viewers going? Where are my viewers going? Is there anything can be done if the jury decides Kyle's guilty? Yes. The judge can set a decide, as a judgment notwithstanding the verdict. Could you explain the bend and snap from the movie Legally Blonde? No, that's okay. Ray says, if I offered you a starring role in a biopic about Brendan Glesson, would you take it? Sure, why not? Get my Hollywood debut? Sounds good. John Kavanaugh said, wouldn't you after sitting through 2 weeks of bullshit? I guess. Regarding the McGinnis question, why wasn't the video addressed by Kyle's defense? I don't know. Rabbi says, who's the first aggressor for deadly force, pointing the gun or the death threat? Well, in my hypothetical, if you paid attention, I presupposed that he didn't hear the death threat or forgot or anything. You know, when I'm laying out these hypotheticals, you have to really pay attention to the prerequisites. So when you said, oh, the death threat, I'm like, I've already taken care of that. So, you know, let's not rehash. Tommy Gunn says 22 rounds of the AR. Matthew said, if jury starts shooting in charges, judges get to ask deliberations. Yeah, I think so. I think so. That'd be the weirdest trial ever, because like, yeah, can he pierce the jury? Yeah, I don't. That's a weird one. If a jury has a firefight until only one remains, is the last person standing to decide the case? No. Someone screen name says, do you think bringing Kyle to stand and subsequent downsides was worth to let Binger piss off the judge and produce ammunition? You cannot see that one coming. Right? You can't see that one coming. So no, it's not worth it. It's a stupid move. Eagle Rider says, why do you believe no one discussed the man in the white shirt shown in the video throwing a rock and hitting Kyle in the back? I don't know why no one described it. I don't know. Your guess is as good as mine. FBI raided James O'Keefe, leaked info to the New York Times. Federal judge ruled to cease all capture of information. Okay. Prosecutor including the defense remains silent after arrest, which only guilty people do. If that happens, the judge will probably freak out and declare a mistrial sua sponte. From my understanding, Kyle's lawyer has never won a case. Who fired shots after Rosenbaum was shot? Don't know. Benjamin Miller says, I can't tell how bad today was for Kyle. I'm confused. I'm never confused, but I am today. It wasn't especially bad, but there was wasted opportunities, particularly for Dr. Black. Menthor said, if the trial is closed, the case is closed, what about the expert they said today they want to bring in a claim Kyle's non-member of the police youth group? And that's over now. The case is closed. Philly Cheesesteak said, how much do you rate the chances of ideological holdout among the jury? Pretty high, I would think. Hobbit, what's the best piece of evidence for each side? I don't know if there's a best single piece of evidence. I don't know that the self-defense cases really lend itself to that. How am I feeling overall today? At the moment, I'm feeling a bit tired and run down, but that's because I've been doing this a while, but I'm going to try to answer some more. Am I right that others were right? It's only important that at pixel level, the gun that no one can see. Do you think the jurors will come out after verdict to speak? I don't know. Resting Bingerface says there was an issue with either juror or someone in the audience this morning. Do you know what happened? Oh yeah. I don't know what happened though. I don't know what happened. I missed it. But yeah. Someone said they talked to one of the jurors, but I missed what happened. What's the likelihood that witness officer Brittany Bray will be found guilty of being sexy? Science works in mysterious ways. Well, I'm a Jeff Mack guy. I always watch, but this is really interesting. Also so helpful with legal experience. I aim for that. I aim for it. I crave it. I'm going to answer... How long have I been doing this? Oh, an hour 28. Jeez, no wonder I'm so tired. I'm going to answer this for another couple minutes, and then I'm not going to finish the bot, but I'll answer at least a couple more. Can the fact the program actively edits the digital image be proof of prosecutorial misconduct? No, because it was disclosed. So it's not prosecutorial misconduct. The judge allowed it in with that knowledge, so it's not misconduct. If he had misrepresented it, it would be misconduct. Logan says the guy had been in a mental hospital. I know. Joseph Cotta said, thank you for the wonderful content. I'm sadly working. Be watching this later. Dixie says, the jury comes to a quick verdict. Do you think it's more likely guilty or not? More likely to be not guilty. When are you going to have the bot update to let you drop all remaining questions from a user? You have to talk to Matt about the increased functionality. Why would they charge first-degree murder? Is anything in Rittenhouse premeditated? I think it's because the multiple deaths. Yeah. I thought Van down by the river Laura said something about having new witnesses. Yeah, that's not happening. Sean Thurman said, thank you for your answers. Richard's just dumb. Yes. Muntop says, how do you deal with live music right next to your house? It's not a problem. They usually finish by 11 o'clock my time, and I'm usually not in bed before then. I kind of enjoy it, to be quite honest. Double D said, I'm new here. What state do you practice law? I'm licensed in Virginia. I work federally, though, because patent law is a federal discipline. If you have a choice of Lismore, 18, or Balvenie, I preferred bourbon to scotch by far. So I'm going to take a pass on both. Logan said, apparently the first guy called. I know that. Thank you. Do you think Kyle will be suing for malicious prosecution? He doesn't have the case. Colonel, listen to the judge's opening day remarks. Is it unusual for the jury not to have access to a transcript? No, it is not. That's very, very typical. Not for at least the reasons that the full transcript includes, like, all the things the jury can't hear. Logan Williams apparently feels the need to follow. That's the same question multiple times. Okay, well, in any case, I'm beat. I'm going to sleep now. To the 1,346 of you who are currently here, thank you very much. Thank you very much for being here and for your continued support and for the super chats. It's really, really appreciated. I really appreciate all of it. Thank you. Tomorrow night, we will be doing, assuming that is televised, we will be doing jury instructions. We'll be doing a full read-through of the jury instructions. Unless, of course, the case is dismissed, in which case we'll be talking about that. But that's our plan for tomorrow. And then I guess Saturday we'll be doing the live react to NYSRPA. But that's upcoming in the near future. Thank you all. If you haven't subscribed already, hit the subscribe. Did you know for a mere 99 cents, you too can become an uncivilian? It's true. You can hit the little button and it'll be great. And remember to hit the like button and the bell and all that stuff. I'll be on with Nick for tomorrow, at least for some of it. Until later, my friends. Hope all's well. Cheers and goodbye.